Ebijan for Ahaya GC News, Mima Obibia Akwaba, Ahadia latest and hot news, Equa, Eramede, Bremo. And we so we subscribe, ya, but Modia say, obe subscribe to channel, Sansa Hadia latest and hot news, Eramede, Bremo. The Obayana say, obe click the subscribe button. Now, what barely notification, or hear the new video be a bear upload on when the first person was Sabeka ASR video. I feel we and I like the video and give us a thumbs up, now fee. Shema or Furióus na when you be here now who and someone ekoso ewo Ghana be mu hanum afi yenhwe eye en someone abeto yepno so etie eye sa report ya ababutuja yentie
eno my Ghana court ni kase court Bata Supreme Court wo mo kwa asetena na kire se de kosi nyina da ne se Futu MP Alexander Afenyo Markins yes said ye speaker and send fast bonkum so pe and what here set minority leader man so kasia woni speaker aban Bagbin etwe no eno ho da running tonto and a chese wo ekokotwe ho manso e wo Supreme Court ho no mo esan se Afenyo Markins se won tie ase da se speaker abu asase said ye MPP mrahye bedwafo so hwan miensa ni sa yenti no wo mo yedom kuma ma no and every so no one majority speaker and send if so pay one more kwakotna I said the speaker ruling by Afenyo Markins in Buanyo so what the America tente edit ninsem akoda Supreme Court on do ruling by sign speaker ruling no de by no nya dia e betimi aye adwuma MPP mrahye bedwafo da so aye majority NDC and so aye minority na just speaker so enam na lawyer fo so ekofale yese Supreme Court so atemmu no a wo mo ede baaye no wo mo fa nto baabi kura essence ekwan a wo mo efa so a wo mo de sa ruling ne e baaye no e ka me ese ekwan ebisuo no emra no wo mo edani ani ebutuye court bailiff kura wo be serve ye speaker no so kura no ekwan a wo fa so no wo no so emra no enya de a wotimi edi so enu di sansen we say yada ene ne Supreme Court ekwa se justice wo mo bobo hu a na se de Ghana fo nyina da ni mu an wo mo hwe kwan do mu nim se wanya wanwa unanimous FC atnasia no nko ade ba kwa wie nyina da unanimous decision ena atia se beba ajaje fo atia asem no mo tena so no enani nyina da no wakwa benkuro me ya se speaker application wo hwehwe se an Supreme Court ruling no mo de ba ye so no ruling no won tontri ba bi kura no speaker so lawyer kwafale ya ne nsem no eyade a wo mabo ede aguon na lawyer fo a wo mu gina mu ede ma speaker aban Bagbin beni baako eye Titus sorry woni Chief Justice Madam Getrude Torkornoo eno mo chechirefo aso wono mo pa e wono na Chief Justice e ka kire ne se wo man o constitutional crisis esanse ade ye mpesi ye behunu ye mpesi ye betie biesi se parliament ye tu ahye da ya suspend ya ye nimu da ye bekoso ne ye tie se de ne ekoso e wo Supreme Court.
A different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete.
Ask the court, please, Ismail.
So, Mr. So, Mr. Sorry, will you be filing anything, or should we hear without you?
Oh no, I don't have instructions on that matter, but especially so that if my lady looks at the affidavit that I filed, I said the order was served on the speaker on Monday, so he has 7 days. I will speak with him, draw his attention to the court's ruling, and then.
So it was served on him on the order was served on him on Monday.
That's Monday.
Monday was 29th.
No, last Monday is the 20th.
Monday, just about 2 weeks ago.
No, wait.
No,
on the 20th. It was served on the 20th.
On the 20th?
No,
and
21st. It was 21st.
So he's gone past the 7 days?
No, but if he's served with the order on that specific date, telling him to file within 7 days, it takes effect on the date of service. That's my understanding.
So he was supposed to file by 28th?
No, by the rules of the court, where the time limited for doing something is 7 days or less, weekends.
So he was supposed to file by when?
If we take out today.
Today?
Yes.
This suit is a Friday for completion. File your processes by close of day tomorrow. This is a constitutional crisis. We are living in a country where the parliament is not sitting. What is going on?
I'm not too sure that this suit is to enable parliament sit. It's to declare.
Very well. Yes, I take it. That's really in your
So
own
if I would plead that because this, look at the time that we are closing and the fact that we've done some work.
Abusuafo wotimi hunu say parliament na chiamehene aban Bagbin say sinidin wo mo nkwati san the MPP fo mu wu Chief Justice wu was a constitutional crisis sadenti and President Akufo Addo teso a obekasa an just a parliament proceedings what to asheda eda ben so wa mandate yenkobiem say and any title sorry say na say Chief Justice enye de ye na be kire say parliament won be kwa na so wo monko nti we grade de o ka kan idi nti na de na kire say ne wote mra me so me wi mra me so me di mra an ye nyina na mra ne yesua we Supreme Court judge no kire say constitution no wa bin so agya sen nti ne legal aid no anase team no penin kese title sorry na wote say oni Justice Torkornoo wo mo achichirafo so e wo Supreme Court wo say kwan ya mo fa so ne matemuo eri ne mu ye nyina da ne kwa bi so no kame esemo breach natural justice na ne nyina da mu no lawyers so gina mu ede ma Afenyo Markins so ye ntie sema hudo bi a wo mo so edi tu edwa e wo Supreme Court ho.
My Lord, is the only court, so regardless of the fact that it's not stated in the rules of the Supreme Court, my Lord, nothing and not erased, my Lord, Constitution to make appropriate giving effect or enabling effect to a declaration. We're not giving the opportunity, the rules of natural justice made by Lord and Randall.
We can only limit us. If you don't mind.
Very well. Okay. That my Lord all said and done. Said and done. Has not breached any procedure of any substantive law, but granted without Rule 79 and Order 81. No, Rule 79 of CI 60.
Eti we say ya Afenyo Markins lawyers ne ba ko sai Supreme Court ruling di onya ba de a wumpo wo so odiso e wo so de ya djuma afei abala ya pani attorney general Gyamfi ya bo adam se de munim no on de paremfo a waje wo Ghana ha de nya asem ketua ko bi otimitisi na MPP wo ya campaign ma on de nti asem ba ya no so go gina mu butu eno no so kwa court wo no mu ne yentie ono se submissions anase na no di semo a no ono so di tudwa je se ni nyina ekọ e de ama Afenyo Markins ene aban no
matter for the interpretation of the Constitution, especially as I earlier submitted, the matter involving the interpretation of the Constitution. There's even no such party as a party who has an interest in the matter, apart from the entire state. Respectfully, it is not for nothing that the Constitution makes the Attorney General the defendant in all actions involving the government, an arm of which is Parliament. So my submission is that
and the Constitution, yes. In all constitutional actions, the Attorney General is required to be a party.
Yes, to be a party. And so the point I make is that indeed the reluctance with all respect.
Abusuafo we say ya balo ya penny Godfred ya bo adame no enti afane efa atwe direction tonto twe apo di won kire mu kotu article subsection cross nyina wie ye pe ena ene agya unanimous decision say de mu anka sam nu dada say we no na nya de be ya de fufuro bia de afi Supreme Court adjefo ho say ye president Akufo Addo nko a ban case nko a de ene akwan bia so no oh ye be di ama no simple kra Chief Justice Getrude Torkornoo ebua ye se ajajifo nyina akobenkura mu se speak wo sini pempen wo sini pen aka kire wo se wo mu ruling na eba ye no wo mu ntimi set na side wo mu kutemu wo mu ginemu enti application kwa na wo no lawyer fa ba be file no eyade a wo mu abo edi agu
and establish decisions of the Supreme Court from decades of the country's constitutional history. Below are the reasons behind our evaluation that the application has no merit. Interpretation and enforcement jurisdiction of the Supreme Court. Article 2, on the very first page of the 1992 Constitution, provides as follows. Enforcement of the Constitution. A person who alleges that A, an enactment or anything contained in or done under the authority of that or any other enactment, or any act or omission of any person, that's B, is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. 2. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. 3. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high crime under this Constitution and shall, in the case of the President or the Vice President, constitute a ground for removal from office under this Constitution. 5. A person convicted of a high crime under Clause 4 of this article shall A, be liable to imprisonment not exceeding 10 years without the option of a fine, and B, not be eligible for election or for appointment to any public office for 10 years, beginning with the date of the expiration of the term of imprisonment.
Abusuafo we say a Chief Justice Mahamadu Getrude Torkornoo and a net wording ruling aba say speaker the audiba ya no application no ya de a wabo e de go esan say MPs and 9 untimi declare one seat ni vacant. One more a nkrofo na musifo e wo mrahye bedwafie na yakwane ne lawyer Martin Pebu akotwetwe nkomo e de afa na de court Supreme Court yi lawyer nwumre ma adwemo akwaba de bakra kasebo eso
yeah
yo de kama mimi sa wo na wodi wani adi proceedings ya e court e wo Supreme Court no mini kan nwa adwen chen fanfa homra
ne e court ne de na mwanwa pa on sa na pay ya call ho no me na me court ho bi na me dwen say speaker when you to a parliament mu no ane na ya ma ba court be buya asem no in such a way say ebema speaker bo atoni yem na we be parliament in tentam but ni nyina ko hwie ye no it me say sere musi buya asem no de nya ade speaker ne bo beju so kra nti anu nti no ama meni anje ne e court o court ne no there be enia ba sere ade ne sit no asem de ye buya enya one answer o ye wo kwan bebre kwan ahoro obetimi afa so no buya asem ne se chiwe se obi abenya bibi e de akofie nso buya asem ne tia oba akofo na chese other side ndi on de wa fa bibi e de kofie and say any parliament yom be no na achekakra
yehwe wabra na Chief Justice any title sorry na cheso mo ye banta kakra wo kan yakosisi o constitutional crisis because ADNT and was a parliament yetimi tum ni akase a suspend sini die no ni ade ade no sa hono mo no nso no metimi akase unya bibi afri mu
and say eno na America no nti so na akase Chief Justice o jikimu say crisis wo the antina speaker inti anu na American begin say osi buya asem no omu num no omu buya asem no enya dia speaker bu beton yem
okay
can ya on be parliament in 10 times inti onu anim say ya to parliament mu no ena e u be buya asem na ye wo kwan ahoro bebira obe faso a e de eyi asundwe ne nkabom beba but say musi buya asem ne no emfa asundwe ne nkabom emma because sila ne na speaker bebi onu gina no ehwa na ogina bebi a court ni gina no ehwa na court ni gina say no nti na speaker to parliament mu no nti na ya court spend the whole day or court ye wie ya obia they've not moved nti na me see say on be buya asem no say we say na me di kan on kan ne lawyer bibi kakra na Afenyo nso enya bibi kakra na afi esa na say oh we say me wini we say me wini say na afi de asundwe ne nkabum aba na speaker be parliament in term because we say MPP members no mo the petition accord down speaker so on be parliament yes Mrasha say ombie, but date corona obebie no, and umrana and sheno, or say within 7 days no, on someone in parliament. Now someone in date or bekase or mumbrano, and the constitution answer the speaker per se or chimutanya, or bet me I can say, okay, any parliament no, what's now or the letter the batter or mumra. Now that ben or mumra, or bet you or mumra 7th December, Sadanona. Parliament Embra Mesha Engagement. Also, the assembly back. And to speak up to me, and Nanke was say, ye we are them no, ye kaya no na, ye no boko, give them something. Ye find the middle of the road, negotiate something with both parties. But where the man is at, ye we are them no good speaker, so into Papa is to say. On Jintum,
Mubaya Day. After Lawyer Yamra, Yara CJ, or didn't rule in the airban and walker, Sir MPs and Nino, Asano, and ya MPs in Nina, some Nemomuno. One would dead and Pessoa who do yet, Dom, and one representing woman, our parliament war. And he speak and me declare seat in vacant. Natural say, constituencies, 4 constituencies, no, Omuniana Musifo, Yenim say, a biasida. And Dressiama for Mina SCA, you declare the seat vacant. Some weeks or months to election. After election, and Sana, one more Enya MP, Yenim Sao, the seat 2020, 4 years ni. One we need an Amusini our parliament. And to work Chief Justice and someone who will general so, Eddie Elbua say, as some Russia baby 4-9. One would die a dumb one muntinu. A quabi suono, speak up for me, and one of them who some say.
Minia, Bacho Udini Bill, Asante Wani.
There be now my Agyarko.
Now my Agyarko. And one no say we yano. And one also say we yano, come, and one no. Intiama obie bisa sal who asemi Andrew Amwakwesi ama asemi. And now okay, menka bakun so na enye fresh enka ho. Constitution ankasa no article 115. O match say obi free ne seat no. Less than 3 months to an election, by election. Constitution says, Obi ye bidina or Shrina Kunyano, less than 3 months to an election, me and by election, Yanjana, Yankoswa Bano, Yaswana, Santos was no new MP. There are some Americans say, in the Constitution, said there are some times people will not have an MP. Yes, even the Constitution itself makes it clear that there are some times that people will not have an MP. International Chief Justice Kennedy Agyapong in classroom. Oh, but I would say the court, the court or no person otchere. Kai said the Biame Kasi law na court ni Buano. I had to say Bible. Bible back way in a kind. I saw you a whole class. So for Becca say 1 2 tighter. With yam rapa. Okwa sorry been so tight and yet by force. Just a may patch and say, Sanso na court in some way we are court no. A sinipa no buya assembuafo no or no no and the best listen. Say the buya asem afa. It is no the tight here. But because hey, when you are tight, I will boom raso. So you'll be on the tight in your asem because when you are tight and yasem. It's a media asem no court. Obiane na dre. Into na or man penny. Said the break Akunya to Supreme Court. In your bio biara no fan Supreme Court judge. Or better that you ask or more. Or who say, hey, me say to me here. Only me, ya jeans the pan. Say the me and Kwabena Agyapong be dear no. Kana, it's me what the man will be dear no. It was a Akufo Addo. Akunya to Supreme Court no be fair ya. All be farmatic because only say or be fat people assemble mediate yano.
Also expects the court to set aside the processes and proceedings which led to
complete the reading of SBD if you want to.
No, my lady, you said the point was made and I was bearing to it.
Very well.
Yes, so I'll do it. So the basis of paragraph 49 yes, my paragraph 49 arises from the observations made by the court before its ruling on the basis of which it made the orders. And
your paragraph 49 is premised on observations by the court
made in the course of its ruling
in the ruling of
18th October, which is sought to be set aside in this application. In the 4th page of the ruling of the court, starting from the 3rd paragraph.
Attached us.
Yes.
Attached us.
Exhibit B. There is a finding by the court that the applicant or the court observes that the applicant urges, and we appreciate that the said ruling would also likely lead to alleged thwarting of government business in Parliament and plunge the due management of the affairs of the country into possible disruptions. And so the court then, on the basis of that, makes its ruling in Exhibit A and notes that.
No, hold on.
Point also, yes.
Hold on.
Yes.
So the partisan political aspersions arise from the observation of the court on the submission of the applicant in that time.
Yes, my lord.
At that time.
Yes, my lord. Because in the ruling of the court, if my lady looks at the 2nd page of the ruling of the court, I think if we start from, the court makes the same observation. Exhibit A.
Exhibit A is not the ruling of the court.
No, my lord, those portions of the submissions that were made to the court were relevant and that informed the ruling. That's what I'm saying. Yes. Yes. No, those were the proceedings.
Yes.
Mr. Sorry.
So it is not. Is not the ruling of the court. So just refer us to the proper exhibit, which contains the ruling of the court.
So I started from the proceedings and I'm now ending with the order. The order also the order just makes the same finding. If my lord should take a look at the paragraph that says the applicant urges the court.
Where are you reading from?
After listing the parliamentarians affected by the ruling, there's the next paragraph which starts with the said 4 constituencies, and then it goes on to say the applicant urges, and we appreciate that the ruling.
So you are reading from Exhibit B.
No, just check A. The order that was sent. Yes. Yes. The cover letter is marked A, but attached to it is then the order of the court. And so that was taken into account before the court then makes the extensive orders relating to even 4 parliamentarians when the writ itself affected 3 parliamentarians. It didn't even include Article 97, 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches the conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex-parte application, and they were heard. What was the balancing?
Sorry.
Yes.
I thought you were just responding to a very straightforward.
Oh yes.
Thing. But now it appears that you are veering into the substance of the motion itself.
No.
I would urge you, rather, to restrict yourself to the objection that he raised and answer it, whether it is scandalous or it's not scandalous.
It is not scandalous.
My problem is,
yes, madam,
if your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it were now, veer into the substance of the application itself.
My lord, I needed to demonstrate that these things were not just said out of any.
No, just restrict yourself.
Oh, my lord, that's exactly. I thought I was doing that.
Yes.
And so, insofar as I'm concerned, apart from the use of the word scandalous, which he just used, he doesn't demonstrate how scandalous it is based on the context of the application that I have before the court.
You allege that the Chief Justice is privy to a breach of a constitutional provision. What are you trying to convey?
It may have been by reason of inadvertence. But if that is a statement of fact,
was it necessary for you to add that in your depositions? For you, what exactly were you trying to achieve By adding the point that the Chief Justice was privy to a constitutional breach. I think that's the point it was.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
But Mr. Sorry, the ruling, if you don't mind, let me draw your attention to the fact that the ruling says that if you look at the first page of Exhibit A,
yes.
we note from Exhibit B the official report on the parliamentary debates on Thursday, 17th October 2024, pages 15, 16, and 17, that the Speaker of Parliament was aware that bailiffs of the Supreme Court had served the current action on him through the legal office of Parliament. His objection to this proper service of a process from the Supreme Court was that it had not been done on a Monday.
Yes, my lady.
That's what the ruling says. So hold on, please. So the ruling was quite clear. The source of the notification.
Yes, my lady. But that's even the source.
If I could land.
Sorry, I thought my lady had finished. I'm very sorry. I thought my lady had finished. I'm honestly sorry.
Yeah.
Should I?
So the ruling was quite clear about the source of the observation that the Speaker of Parliament had been properly served. And the ruling appreciated the circular, administrative circular from the Chief Justice. The first Chief Justice was Chief Justice Edini Eboa in 2021, and myself issued another circular which clarified how all of Parliament was to be served. That is what you are referring to. Is that not so?
Yes, my lady.
And how does that veer into a partisan political agenda, including constitutional breaches?
The two are independent. Let me deal with the first one. My lady says the finding even by the court that it was proper service is the point we are making. That by reference even to the parliamentary proceedings that took place that day, it was clear. It is not, first of all, it's not the official report because it was just a draft one. Parliament had not yet gone through it and adopted it as an official one. But the second thing is that the court could not have found without referring to the judicial circular in which the proceedings had indicated clearly that the first defendant was objecting that it was not in accordance with that. And the plaintiff appreciated it. So that is it. And this other, with regard to the partisan aspect of it, that one is distinct. It's a distinct point, and that one is based on the submissions made to the court that, based on the assumption that if one party is the majority, it is deemed that government business will be thwarted. That's based on that assumption. Because if the Speaker's ruling state, there was nothing to show that whichever party was the majority or otherwise, government business will be thwarted. And the Constitution doesn't assume that the government in power would necessarily have majority in Parliament. So those were the issues that were raised clearly on the face of the documentation.
Sorry. Are you still addressing the preliminary legal objection raised by the attorney, or we are dealing with a substantive matter, i.e. your motion to set aside the protest?
Oh no, I'm dealing with that matter, but I'm also responding to questions from the bench, showing why, if my lady says that it was based on the proceedings in Parliament, I'm answering that.
Kindly round up.
Yes, so my lady, there's nothing scandalous about it. They are based on matters of fact that arose out of the proceedings before the court, on the basis of which the court made the orders sought to be set aside. Yes, ma'am. Yes, ma'am.
Accuse that member of being, when the decision that is taken here is a collective decision by you isolate one member in your decision and accuse that member of being privy to a constitutional breach. You think that it's a proper thing for us to make this?
Well, first of all, it's not a proper inference from the affidavit because the person whose judicial the judicial circular does not make reference to the full membership of the panel. Oh yes, yes, because she was named in the circular. The rest of the panel was not named there. Yes, but I'm giving the background to that application.
I think it's not permissible.
I'm not accusing, and to turn it into an accusation, it's not a fair inference to be drawn from the affidavit. Maybe my lord is borrowing his words, and then I have to answer.
Sorry, are you able to allow the court to tell you something?
Oh.
The proper practice at the bar is when the judge starts speaking, you stop. Do you not appreciate that?
Oh, my lady, I don't think my lord thought I interrupted him. I was just responding.
I beg your pardon.
Then you shall. It's a prosper. I don't think. My lord, I don't think.
Are you able to let my lord land before you start speaking? So we can have an orderly conduct for today's event.
So that's my worry I'm expressing. But when the court is, I don't think it's proper to isolate from them. Whether she knew or she don't know. I say, part of it, it is actually an accusation across the board. You should know better.
My lord.
My friend has raised an objection. I would have thought that the gentleman did things to have done to have been sealed. Because what we have done is to isolate individual members of the panel and accuse them of constitutional breaches. And you know how serious that is.
Well, can I answer? Very well. So, but I'm saying that it's not a fair inference from the affidavit, and with all due respect, we refer to a circular that had nothing to do with the panel, and so it wouldn't have been right. I would have been misrepresenting the circular if I put it in those terms.
Yes, Mr. Abedu, can we hear you on this preliminary point? He's done.
No, but is he done?
But yes, he's done.
I totally associate myself with the concerns raised by the Attorney General, and I have nothing more useful to add.
Second. Sorry.
Now, Mr. Sorry, can we hear you on your objection?
My lord, the right of the president arises from some of
that, my lord, on the extreme what?
Right to my lady the Chief Justice, to him being impaneled in this matter arises from the fact that at a point in time he was known to be associated with the New Patriotic Party. And in fact, he was a parliamentary candidate in one of their constituencies in the Volta region.
I think you said enough.
Very well. And
yes.
I just want to demonstrate from, especially again.
No, I think you said enough.
From the
I think you
proceedings
said,
and the
no, I think you said enough. Kindly resume your seat.
Very well, my lady.
Let's go.
No. Don't call.
This is like just case communication with the fellowship use.
Registry.
My Lord, with respect.
You gave your privilege of please stand. You gave your privilege of addressing the court to your junior, so we will not hear you, not on these matters.
My Lord,
we will not hear you.
I apologize. I was sitting in Parliament. When the speaker is talking, you sit. You don't stand. So when I make this mistake, accept it. Yes. And my junior,
please, Mr. Gatti, we will not listen to you at this point.
Okay. When you're ready, when now you decide that you are.
Mr. Gatti, we will not listen to you.
I'm just saying that, my Lord. If
the court will rise now to give a.
Then you.
All rise.
Yo, waiting for winning and some ababeto yepuno so make out say so when you subscribe to channel ya bomodi ase obe subscribe and say hadia latest and hot news in kwa enamede bremo afi we are no like video no like the video na fi share ma ofoforo so na wonye bi hwe na wo hu ensemo ekoso wo Ghana mema oso betimi achere wadwen afa eye ensemo nyina ho wo comment box ni mu mobati minkabium in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.